Hey there, welcome to another episode of CVN's Trial Technique Spotlight. For those of you who don't know me, my name is Shane Reed. I'm a trial consultant. I do everything from mock juries to focus groups to helping attorneys get ready for not only trial but for depositions. And I'm going to show you today a clip from an opening statement of how the trial was won, not at trial, but at the deposition that it was so good. And when I'm working with lawyers, I'm always working with them on how to ask that one question that will win a deposition that will help you win at trial. And we've got a great example here from Jake Plattenberger. I just loved what he did. So let's watch it and then we'll talk about it in just a moment. So here it is.
As we get started, I want to introduce you to Abbott. And, a corporation can only speak through its employees. And I'd like you to meet Dr. Bridget Barrett-Reese. She is a senior associate, or she was, apparently she recently retired, a senior associate research fellow at Abbott, okay? Very, very high up on the science side. She was one of the people that was in charge of their nutritional product lines and understanding how those nutritional products interacted with human beings. She was at the company for, somewhere between 20 and 25 years before she retired. And so this is not like a temp employee. This is somebody who was there for a long time and who was involved in a lot of the decisions that brought Abbott into this courtroom to be facing you today. So I have a short clip from Dr. Reese that I want to play. You're going to hear my partner, Mr. Herman. As the judge told you, we have a lot of deposition clips in this case. We try to make them as short as we can. We try to make them as watchable as we can. But anyway, this is Dr. Reese.
Certainly you can answer this. You would agree that it would be inappropriate for Abbott to intentionally mislead healthcare providers or consumers about the risks associated with its products?
And you're using the word mislead, really. Can you think of a better word than mislead?
No, that's the word I want to use. Intentionally mislead. Certainly it would be inappropriate for Abbott Laboratories to intentionally mislead consumers about the risks associated with its product. Seems like a pretty simple question to me.
But it's another one. I think the words are ambiguous enough. I don't want to answer it.
You don't understand the word mislead?
Mislead can mean a lot of different things. We all know that.
We all
know that mislead means a lot of different things. So it's another one I'm not answering because mislead can mean a lot of things.
So you want to answer
Give me a better word than that, I might answer it.
I can't think of a better word than mislead.
Well, then I can't answer it.
How about lie?
Well, they should not lie. If the
Okay.
word is lie, that's different. But
So
mislead-
you would agree that it would be inappropriate for Abbott Laboratories to lie to the public about the risks associated with its products?
I can't answer that, sir.
You can't answer
I
whether
don't
it's...
know in what context you're asking me it, so no, I cannot answer.
Let me ask you the converse. Are there times you can think of where it would be appropriate for Abbott Laboratories to lie to healthcare providers and consumers about the risks associated with its product?
So you're asking it the other way around?
Yeah,
You're
converse.
asking me to answer it?
The converse way to ask is, do you think there are times that it's appropriate for Abbott Laboratories to lie to healthcare providers or consumers about the risks associated with its products?
I can't answer it.
You can't answer that?
Nope.
These are usually not difficult questions for people or corporations to answer. Is it okay for you to lie to the public about serious risks associated with your product? Is it okay for you to mislead the public and healthcare providers about serious risks associated with your product? And the answers speak for themselves.
All right, let me give you a little context for what happened. The plaintiff was suing that Abbott had misled the public about its baby formula, and this little child was a premature baby in the neonatal care unit and had horrific problems from allegedly using the formula. So in the deposition, the witness will not answer the simple question, would it be inappropriate for Abbott to mislead the public about the risk associated with its products? Now, the witness, in fairness, was probably worried that the lawyer might be twisting her words. But the reality is, mislead is not hard to understand. The jury understands what that word is, and the refusal to answer it indicated, hey, maybe Abbott was misleading. But the lawyer in the deposition did something even better. He said, well, if you don't like the word mislead, how about lie? Would it be inappropriate for Abbott to lie about the risk involved with its products to the public or healthcare? And the witness then still said, well, I can't answer that question. And then the attorney said, well, let's do the reverse. Are you reverse? Would you say it would be appropriate to lie? And the witness still wouldn't answer it. I mean, you've won your case right there, but what Jake Plattenberger did so well is he used that video clip, the beginning of his opening statement, as a demonstrative exhibit. Beautifully done. The jury's immediately on his side. He's connecting with them. It was a $495 million verdict, $400 million in punitive damages. That 2-minute video clip was the key. Hey, I hope you enjoyed this trial spotlight. If you want to learn more about what I do for jury consulting and helping lawyers in depositions and trials, click on the link down below and use all of CNVN's resources to learn how to become a great trial lawyer. All right, see you next time.